Talk talk, yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. A Louisiana rapper with decades long history in the criminal justice system is now facing a felony charge in Harris County, Texas, and it is putting a 3-year federal supervised release deal in serious jeopardy at the same time. I'm going to walk you through exactly what the charging documents say, what's alleged, what the bond conditions look like, and why the Houston case could carry consequences all the way back to a federal courtroom in San Diego. I'm Cassandra, aka your favorite paralegal, and this is Legal Doc Talk. Let's get into these documents. So, what I do have up on the screen is the charging document, okay? So the defendant here is Torrance Ivy Hatch Jr., also known as Boosie Badazz, aka Lil Boosie, who is a Baton Rouge, Louisiana rapper. According to Harris County court records, he is charged with aggravated assault with a deadly weapon, which is a second degree felony under the Texas Penal Code 22.02, in connection with an incident alleged to have occurred on May 24th at a nightclub downtown Houston on Main Street. Quick disclaimer up front: this episode is based entirely on court filings, charging documents, and reporting that I am pulling, or any documents that I am pulling from the Harris County District Clerk's office. Everything I describe as alleged is alleged. Hatch is presumed innocent, and his attorneys have publicly disputed the state's version of these events. Okay. And it's sad that I have to say this, but everybody take a lot of stuff out of context. Out of context. I am a legal document reading channel where I break it down so you guys can understand. All right, so let's get into this charging document. Here's the sequence laid out in the filings, as reported from the documents that were submitted to the Harris County District Office. I have the document on the screen, so if you want to pause and read, you can. And I will actually, let's do this so y'all can see this. It's 2 pages, and I'll scroll down in a second, but so you guys can actually read it if you want to. So around 2 a.m., May 24th, the club was closing. A security guard identified in the reporting as Edward Eagleheart was posted at the door helping to clear out the patrons. A woman, later identified as Bootsy's niece, asked to use the restroom. The guard denied her because the restroom was already closed for the night. According to this filing, she became upset and struck the security guard in the face with her elbow. As the guard continued escorting her out, she dropped her phone and keys on the floor. The guard bent down to pick up the items for her. That's the moment everything escalates. According to the guard's statements in the documents, as he was bent over, he felt something strike the back of his head and felt blood running down his face. When he looked up, he says he saw uh, Torrance, Mr. Hatch, standing there holding a broken glass hookah base. And if y'all done hookah, y'all know how big them things are, okay? A security guard A second security guard that was present nearby told investigators he heard glass shattered, then saw the first guard bleeding from his head. He says he saw Hatch holding the broken hookah base and yelling at the injured guard. Both guards identified Hatch by his stage name, and notably, the following state they were shown a photo of Hatch displayed on the club's big screen to confirm the identification. Court documents also indicate club promoters and owners separately identified him as the person involved. The injured guard was transported to the hospital and received 8 staples to close the head wound. Whew. This charging language alleges Hatch intentionally, knowingly and recklessly caused bodily injury to the guard by striking him with the hookah base and using the object as a deadly weapon, which is aggravating element. Which is the aggravating element that elevates this from a misdemeanor assault to a second degree felony. So because he wasn't taken into custody, y'all, at the scene, prosecutors sought and a warrant was issued for his arrest after the investigation. He appeared in Harris County Court on June the 1st, 2026. At the hearing, the court set what's called a walkthrough bond of $85,000. So, for anyone unfamiliar, a walkthrough bond is a mechanism that lets a defendant with an active warrant resolve it and post bond in a single court appearance without being physically booked into the county jail first. His attorney at the time, William Van Buren, confirmed the walkthrough process was used here. Later reporting also identifies attorney Carl A. Moore representing Boosie Badazz. Reported conditions of release included staying away from the venue and no contact with the alleged victim, which is standard conditions in an assault case involving identified witnesses at a specific location. Following the hearing, Hatch addressed the case directly on social media. Y'all know Boosie always go to his social media, y'all, calling the charge basically a money grab and stating, quote, the facts of the case will come out. His attorney has publicly stated the defense intends to pursue the venue's surveillance footage and has asked the public to reserve judgment. Moore has also characterized Hatch's actions that night as defending a female relative being escorted from the club. The next court date is set for September 15th, 2026. All right. And I believe that's the trial, but I have to go check that docket right, quick. All right. So I never covered this case initially, but when it first came out, it was actually in switch courts, actually. I believe it's switch courts. But there's been real movement on this case, and it does tell us the news don't tell us. This case has been indicted and is now pending felony proceedings in the 208th Judicial Court in Harris County. That is different than the walkthrough bond hearing back in June. So a felony case doesn't land in a district court with a new cause number unless it's been indicted or otherwise formally moved onto a felony trial docket. So on June 23rd, 2026, defense attorney Carl A. Moore filed a coordinated package of pretrial motions with the Harris County District Clerk. And let me get to that. Now, these are the pretrial motions that I was telling you guys. I need to see exactly how I'm going to if y'all want a copy, y'all just let me know. But these are all the pretrial motions. I'm not going to scroll through I'm just going to have this the first page on here, but I'm going to read to you guys exactly what this pretrial package includes. This is a standard defense move at this stage, y'all. But it is worth walking through because it tells you exactly how the defense plans to fight the case at trial. I repeat, yes, it is a standard move, but it tells you how the defense plans to fight the case at trial. Once again, if y'all following me with the Carmelo Anthony case, y'all noticed, and I pulled the court dockets, none of these pretrial documents were even on there. But I digress. Let's go ahead and walk through what's actually filed. This is 110 pages that I pulled from the Harris County website. The package includes roughly 20 separate filings, each substantive motions paired with a proposed order. Because anytime you file a motion, you have to file a proposed order. Why? Because When you file a motion, it gets set for a hearing. If the judge wants to grant or deny, he has to sign something granting or denying. So that's why a proposed order is there for the judge to sign. But here's what's in it, and it's grouped by function. So I don't know if you want to get your pens and pads ready so you can write this down. The first group is discovery and disclosure motions. These ask the state to hand over information before trial. So in that category, here are the different type of motions. A motion for disclosure of any documents used to examine witnesses or refresh their memory under Texas Rule of Evidence 611. A motion to list the state's witnesses and request their criminal histories. A motion for disclosure of impeaching information, anything that could undercut a state witness's credibility. A motion for production of information concerning the state's witnesses. A motion for discovery of scientific evidence. A motion to disclose expert witnesses, the state intends to call. All right, so these are uh, motions where they're asking the state to hand over information. So y'all see that? I know y'all can't see it, but if you're written it down or you heard it, y'all listening to what I'm saying? All right, so kind of compare what the defense is doing here versus what they have done in Carmelo Anthony's case. The next group of motions is called evidence handling motions. So, a motion for examination of physical evidence, a motion to designate the location of physical evidence, basically making sure the defense knows where the evidence is being stored and has access to inspect it. Motions, and then the next category is motions targeting specific evidence or testimony. So, a motion to suppress defendant's statement pursuant Jackson versus Dino. This one is significant because it tells us Boosie made some kind of statement, and the defense wants a hearing outside the jury's presence on whether the statement has made voluntarily, if it was made voluntarily before any jury ever hears it. The next motion would be a motion to prohibit the state from introducing statements allegedly made by the defendant without a prior hearing on admissibility. Excuse me. There's also a motion for a hearing to test the qualifications of the prosecution's character and reputation witnesses, meaning the defense anticipates that the state may call witnesses to speak to Hatch's character and wants to vet them first. The last in this category would be a motion requesting notice of the state's intent to use certified copies of official written instruments. Okay. The next category of motions are trial structure motions. So there's a motion electing to have the jury, rather than the judge, assess punishment if there's a conviction under Texas procedure. That election has to be made prior to trial. Excuse me, prior to trial. Then there are also 7 separate motions in limine. I'll explain to y'all in my Carmelo Anthony videos what what the motions in limine are. Okay. A motion in limine asks the court to instruct the prosecutor, their assistants, and the state's witnesses not to mention certain categories of prejudicial information in front of the jury. Things like extraneous bad acts, hearsay, or reputation evidence without first approaching the bench. This is a preemptive strike to keep prejudicial material out of the jury's ears unless and until the court rules it's admissible. I hope you're learning something here in this Boosie Badazz case. None of this should be read as unusual or aggressive. This is a close to the standard battery of pretrial motions a competent Texas criminal defense attorney files in nearly every serious felony case, y'all. But two filings do tell us specifics about the defense anticipated trial strategy. The Jackson versus Dino motion confirms that Boosie gave some kind of statement that's now going to be litigated over its admissibility, and the motion in limine covering character and reputation evidence tells us the defense is bracing for the state to try to get to Boosie's reputation or prior conduct in front of the jury, which, given his criminal history, is exactly the kind of evidence the defense wants to ward off during the innocence phase. Each motion came with a proposed order for the judge, meaning we should be watching the docket, and I'll be watching the docket for whether those actually get signed, if they get denied, if there is a hearing, since the rulings on the suppression motion is particularly could shape what the jury gets to actually hear. And I'm sorry, I'll be catching myself saying and I try not because I that's a pet peeve of mine and I say it a lot. So I do apologize. Let's get into this the federal part, y'all, the federal part. Cause we just talked about ah, God darn it, Boosie. This guy. Shut up, Leslie. And my dog would bark as I'm doing this. Because this case gets a lot more consequential than a standalone Texas assault charge, because Torrance was already under federal supervision when this happened, y'all. Back in 2023, Boosie was arrested in San Diego and charged federally with possession of a firearm by a convicted felon. The underlying felony being a 2011 Louisiana conviction out of East Baton Rouge Parish for possession with intent to distribute Schedule 1 and Schedule 2 controlled substances, plus a separate 2011 conviction for introducing contraband into a penal institution and criminal conspiracy to incite a felony. Reporting indicates the firearm in the federal case, which was a loaded Glock 19, was found by officers during the filming of a music video. That federal case resolved in January of this year with a guilty plea, 10 days time served, a $50,000 fine, 300 hours of community service, and 3 years of supervised release. Supervised release comes with conditions. Two of those conditions are now central to what's happening in California. And guess what those conditions are? No new criminal charges during the supervision period, no travel without prior court probation approval. According to the federal probation supervisors in the Southern District of California, Boosie violated both of those, y'all. He was in Houston and headlined as a performer at the club without getting prior approval from his probation officer, and now he's picked up a new violent felony charge in Texas. And I know Boosie be traveling. I know, because my cousin be rapping. Oh my gosh, y'all. And he's done a couple of tracks with Boosie and a video. But anywho's, probation also disclosed that January 2026 drug test came back positive for cannabis. Oh my gosh, for cannabis, y'all. For cannabis. Another violation of standard supervision's conditions. You can't be drinking, you can't be smoking, you can't, I don't understand why people can't follow the orders. And the crazy part is, I think they be so happy that, okay, yeah, I got off, da 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 da. They don't actually read the order. They don't read the order, or or they may just think that they're untouchable. The federal sentencing recommendations doesn't hold back. That's what I have on my screen. So I highlighted the part where it speaks specifically to the probation recommendation. So it states Hatch has failed to capitalize on the opportunity afforded by the court, and that within weeks of starting supervision, he exhibited a pattern of noncompliance. It goes on to describe his longstanding involvement in the criminal lifestyle and cites violence, weapons, possessions, antisocial peer associations, and illegal substances abuse. Now, when I pulled the federal court filings, the defense will make it one way. They showed how he is in the community, how he is helping with uh, back to school functions, giving to the homeless, his honorary degree, so on and so forth. Then you flip over to what the state, or I should say, yeah, the state, the federal portion of it at least, they have they have pictures of him holding a gun, all kinds of stuff. I'm just like, wow, this is crazy. But based on all of that, probation is recommending 18 months in federal prison to run consecutively with whatever sentence results from the Texas case. An additional 18 months of supervised release for any prison term, a requirement that Boosie submit to court ordered searches of himself or property going forward. Judge Kathy Ann Bensavingo is the same judge who handled the original Pew Pew case. She declined to issue a bench warrant for his arrest, but did issue a summons requiring Boosie to appear before her. Here's the legal nuisance I want to flag for you guys. In a revocation hearing, the court does not need a Texas conviction to revoke supervised release. Revocation hearings use a preponderance of evidence standard, the same more than likely not than not standard used in civil cases rather than beyond a reasonable doubt standard required for a criminal conviction. That means Judge um, Bensivengo could find a violation occurred and revoke his supervised release, even if Harris County case is ultimately dismissed, reduced, or result in some type of acquittal. That's a critical distinction for anyone following the cases in parallel. They are legally independent tracks with different standards of proof, and one can move forward regardless of what happens in the other. So, what happens next? All right, where are we at? So, in Harris County, aggravated assault with a deadly weapon, second degree felony, now pending in the 208th District Court. It exposes the exposure of 2 to 20 years, y'all, 2 to 20 years if convicted as charged. A full pretrial motions package, which include Jackson versus Dino suppression motion and several other motions in limine, was filed June 23rd. The next setting is on September 15th. I should have not closed out because I need to see exactly what that is. Then we have the Southern District of California. Supervised release revocation proceeding, summons issued, probation recommending 18 months custody plus 18 months additional supervision consecutive to any Texas uh, sentence. A few things I'm going to be tracking for us going forward, is whether the court rules on the Jackson versus Dino suppression motion and what that tells us about the statements that he made itself. Whether the motions in limine get granted, meaning we'll see what categories of evidence the state is barred from raising without a bench conference first. Whether the defense surveillance footage request changes the picture. What happens at Boosie's federal appearance before Judge Bensivengo. And whether Texas case gets resolved before or after the federal revocation hearing, given they don't have to move on the same timeline. Whew, this is a lot. but I'll keep pulling documents on this one as they are filed. If you want to deep dive on the federal supervised release standards, the walkthrough bond process, or the deadly weapons enhancement work in Texas assault cases, let me know in the comments and I'll break those down in a follow up video. But definitely, guys, if you like this video or you don't like it, hit the like button. Subscribe so that way if I go live or I put out a new video, you are notified. And I will catch you guys in the next one. Bye.